to the internet. What about the history of government regulation and the fact that those who are regulated have acquired positions of power because of their license from the government and so on? No such thing. No history, no government licensing. Nobody's been put in a preferred status because of government regulation, unlike broadcast. And this medium is not invasive the way radio was in Pacifica, the way television can be coming into the home, that you have to work at it a little bit to get it, that it's not quite so accessible to children, makes a difference. So Justice Stevens rejects the government's argument that broadcast level scrutiny is what should be applied to the internet, and says that there's no reason to qualify the level of scrutiny applied to the internet, which I take to mean that internet communication is at least as free as any other medium of communication, including print. Therefore, what you've got in the Communications Decency Act is a content-based law singling out indecent or patently offensive content for criminal proscription. Since it's content-based, that triggers strict scrutiny, and that requires the government to show that restrictions on internet speech are justified by a compelling government interest, that the restrictions are narrowly tailored to serve a compelling interest, and that there's no less restrictive means, less restrictive than criminal punishment. That's pretty restrictive, but there's nothing less than criminal prosecution that will serve to meet the government's compelling interest. In other words, instead of giving the government the benefit of the doubt, the burden's on the government to show compelling interest, narrow tailoring, no less restrictive means. Well, the court, for better or for worse, assumed that the government has a compelling interest in protecting children from sexual material on the internet. Didn't really analyze it, didn't require the government to show that any children are harmed in any way by seeing something dirty or finding dirty words on the internet. The court simply assumed that the government had a compelling interest, and therefore turned its attention to whether the law was narrowly tailored to serve that interest. And the court found that, in fact, the law was overbroad, overbreadth being a First Amendment concept, that the law sweeps within its ambit speech that is protected, a substantial amount of speech that is protected, at least protected as to grown-ups, and makes it criminal. And the court says that the government can't reduce the adult population to only what is fit for children on the internet. The level of discourse cannot be limited to that suitable for a sandbox. So overbreadth is one constitutional defect that the court identified in this law. Maybe there's some material in there that children should be shielded from, but it also prohibits this whole range of material that adults have every right to see and hear. In addition to overbreadth, the court found that the law was vague, using the First Amendment concept of vagueness. That is, that you can't really know from these undefined open-ended terms like indecent and patently offensive, you can't be sure whether what you're about to put up there is going to subject you to criminal prosecution. And that has the proverbial chilling effect on perfectly proper speech, that you don't dare put it up there because you don't know what the government is going to do. And here you have not only two ambiguous terms, indecency and patent offensiveness, but you have one in one section of the law and another one in the other section of the law, and you don't know how they relate to each other, and neither of them is defined. So because the law was both vague and overbroad, it was not narrowly tailored to serve the government's interest in protecting children from exposure to sexual material, and therefore was unconstitutional under the First Amendment. The government didn't give up easily. They asserted another interest, separate from their interest in protecting children. They said that we need to police, exterminate, limit, restrict sexual material on the internet, which is flooding the internet, because we want to foster the growth of this medium and make it useful for everybody. And its usefulness is impaired by all of this pornography that's all over it. And therefore, we need to rid the internet of this nuisance of indecent material. That's somewhat reminiscent of the government's rationale for regulating radio back in the 20s. In order to make the medium useful, some kind of government regulation is required. Justice Stevens gave that last-ditch Hail Mary argument at the back of his hand. He says, in our constitutional tradition, we presume that governmental regulation of the content of speech is more likely to interfere with the free exchange of ideas than to encourage it. The interest in encouraging freedom of expression in a democratic society outweighs any theoretical but unproven benefit of censorship. And of course, the factual underpinning of the government's argument was all wrong. People were not deserting the internet or fearful of the internet because it had some pornography on it. Rather, they were flocking to it as fast as they possibly could, and not because of the pornography, because everything's available there. And here it is, the most democratic medium ever invented, and everybody's participating in it. What about obscenity? Why didn't the court deal with obscenity in the Communications Decency Act case? And that's because it was not challenged. The ACLU made a tactical choice in bringing the lawsuit challenging the constitutionality of the law, not to challenge the obscenity prohibition, assuming that the court would likely say, as it had said time and again, that obscenity is an unprotected category of speech that has never been protected by the First Amendment, and it's unlikely that the court would change its mind on that and say, oh, well, now that we've got this new medium of communication, obscenity can be is permitted on this new medium. So that was left undone, and the decision stands as the first and most important decision on internet communication, completely protective of communication on the internet. The Congress couldn't stand it. And within a couple of months after the court's decision in Reno versus ACLU, the Congress enacted a new law that they said would patch up the deficiencies, the constitutional deficiencies that the court had identified in the Communications Decency Act. All of these abbreviations for the act will completely make your head spin. I mean, in the Reno case, you have the Communications Decency Act. Now we're going to have COPA, the Child Online Protection Act of 1998. And what the Congress did was limit the reach of the new law to material on the World Wide Web. We're talking about website here, not about email or chat rooms or other parts of the internet. You're talking just about the World Wide Web. And Congress limited the reach of the new law to communications for commercial purposes. Maybe they were thinking commercial pornographers who sell their material online, and maybe they weren't, but what they said was for commercial purposes. But they didn't limit it to profit-making entities. Nonprofits can put things online for commercial purposes. They can sell content online for commercial purposes, even though they're nonprofits. And finally, and perhaps most troublingly, the Congress came up with a new kind of speech that would be prohibited. It wasn't indecent, it wasn't patently offensive, it was harmful to minors. And they put in a definition of what is harmful to minors, which is a parody of the Miller versus California obscenity test. What the Congress did is tack on to each of the three factors governing obscenity the words with regard to minors, or for minors, so that the material has to appeal to the prurient interest with regard to minors, with respect to minors. It has to be patently offensive in its description or depiction of sexual or exploratory acts with respect to minors. What does that mean? This is the bastardized obscenity test that California used in the video games case. Same idea. Take the obscenity test. We know that obscenity is illegal, and we'll tack on something about minors and be able to argue, oh, it's not protected speech. And then finally, they say, and the speech has no literary, scientific, political, artistic value, quote, for minors. And so that's the law that they passed. The day it was to take effect, the ACLU and others brought suit, once again, in federal district court in Philadelphia, same court where they'd started the CDA case, the Communications Decency Act. They sought and immediately obtained a preliminary injunction stopping the law from taking effect. The government appealed the preliminary injunction to the Court of Appeals for the Third Circuit, sitting in Philadelphia, and the Court of Appeals engaged in a lengthy discussion of the law and what it provided and what it didn't provide, but it was particularly troubled by the community standards provision governing patent offensiveness. That material must be patently offensive in its description or depiction as judged by contemporary community standards, and the Court of Appeals pointed out that this is a worldwide medium and that you can't allow censorship of this medium, that maybe the source of it is in New York or San Francisco or Chicago or Frankfurt, or it could be anywhere in the world, and have it judged by the least tolerant community that the prosecution can find in the United States, where they're going to bring prosecution against you in Logan, Utah, or Greenville, Mississippi, some Bible Belt town where the community standards are extremely strict. But your audience is worldwide and sophisticated and so on. And the Court of Appeals said that the use of community standards for judging the forbidden content invalidated the law, and COPA was unconstitutional for that reason. And the government appealed to the Supreme Court, which decided in COPA 1, the first Child Online Protection Act case, that the use of community standards to judge the forbidden material by itself alone was not sufficient to invalidate the law. The decision was written by Justice Clarence Thomas, who pointed out that COPA was much narrower than the Communications Decency Act in the three respects that I mentioned, and didn't apply to as much speech as the CDA did, but was candid. Justice Thomas was candid in saying what really animated the court in deciding that the use of community standards didn't invalidate this law. What really animated was the realization that if we throw out community standards here, we open the door to obscenity on the internet, because obscenity is judged by community standards. We say that can't be used here, then obscenity floods the internet. And Thomas offered some blunt advice to web publishers that if you don't want to risk offending these little conservative communities tucked around America, choose a medium of communication that does not target them. In other words, go into some other business. Use a different medium of communication whose standards you can live with. Communicate by a newspaper or broadcast or whatever, but you can't do it on the World Wide Web. And the court decided, since the Court of Appeals had gone off only on the community standards issue and hadn't reached the other First Amendment arguments about whether this law stands or falls, that the case has to be remanded to the Court of Appeals for a second look. Slap their hand, slap their wrist, tell them the fact that this law involves the use of community standards does not invalidate the law. Now look at the bigger picture. Does it violate the First Amendment on overbreadth grounds or on vagueness grounds like Reno or not? So the Court of Appeals revisited the case and decided that COPA, like the CDA, was both overbroad and vague, and therefore unconstitutional, not narrowly tailored to serve the government's interest in protecting children. And the government, of course, went back to the Supreme Court on another appeal, and this time the decision for a 5-4 court was written by Justice Anthony Kennedy, upholding the preliminary injunction that had been granted on the grounds that this law was not narrowly tailored and was overbroad, and it was overbroad and not narrowly tailored because there are less restrictive alternatives, less restrictive means than criminal prosecution that the government could use to protect children from exposure to material that may be harmful to them. Those less restrictive means were software filters that parents could use if they wished, could install on the computer to screen out material that the parents didn't want their children to have. Let me ask you, how many of you encountered in your homes software filters? Right? Yeah, Brendan. Yeah, really. So, anybody else? Yeah, Catherine? Is that Catherine? Yeah. And did you know how to disable them? Yeah. But that's it. Only, I mean, I thought the use of filters was fairly widespread, no? For your kids, now. That's a dangerous age, isn't it? And how do you have it programmed, and how do you... So mom had decided, is it by sight, or...
And so, yeah, he whines and whines because he wants to go on the side of the site. But in order to say what the
Right.
crime scenes,
Right.
They'll figure it out soon enough. I know it.
So, and you're satisfied that it works, that it does the trick, the trick that you want done.
For now, yes.
Yeah. Well, apparently, Jen? Right. Yeah.
I remember having friends who told us a little bit as a kid, but when it was very young. I remember they used to in high school computers at my school that was on them, and we all knew how to get around it. Like image search, we were researching computer lab, like on Wi-Fi at school. You couldn't get on TV, like do an image presentation. So everybody would go like Australia's Google or China's Google. So I just think I thought it was weird. School can do that. Like I don't know that. I don't know. It's interesting. Like students were 18 working.
Yeah. Well, we'll come to the school issue on Thursday. I mean, the court was quite persuaded that these tools, filtering software, were effective and were certainly less restrictive than criminal prosecution in serving the government's interest in restricting children's access. The court recognized, Justice Kennedy's not terribly naive, he recognized that the filters are not perfect, that they overblock, they block material, which is perfectly fine. I mean, if you put in sex, for example, and sex is one of your places, one of the terms that you can't use in search, well, you might bump into our syllabus in this course, for example, you couldn't get access to it because it uses that word. Go ahead. They didn't address that issue. They didn't address whether the term harmful to minors, as defined in the law, was vague. It did address whether it was overbroad, although not at this stage of the case. Justice Kennedy is dealing only with a preliminary injunction at this stage of the case, and affirming the lower court's grant of a preliminary injunction, recognizing that the filters overblock something and underblock something, as Justice Breyer pointed out in dissent. These filters can't filter by image, only by word, so that the filter cannot distinguish the rawest kind of pornography from the Venus de Milo, for example. The filters are incapable of doing that. They're word-based filters. And Justice Kennedy points out that the filters are more effective than criminal prosecution in dealing with foreign-originated pornography. At least half, apparently, I don't know how they come to this figure, but at least half of the sexual material on the internet originates from sites abroad. We can't prosecute them in this country. We can't catch them. They're not here. They don't have assets here. There's nothing we can do about them. But the software can block those sites and access to those sites. And so that's more effective than criminal prosecution, which is not practical with regard to foreign-based sites. And Justice Kennedy concludes that the government has not proved that filters are less effective than criminal prosecution. And then Justice Kennedy decides to remand the case back to the trial court to allow the government to make a better case, to prove that filters are not as good as criminal prosecution, and so on. And Justice Breyer is apoplectic about that. He says filters can't distinguish between the most obscene pictorial image and the Venus de Milo. Why do we have a trial at this point? We've had 2 laws and three decisions, and what else was Congress supposed to do? And then he, unlike Kennedy, did look at the definition of harmful to minors and picked it apart, took each of the 3 things, and saying that if you apply that test, very little material that is not obscene would be found to violate this law. That is, you look at prurient interest with respect to minors. Well, it's got to appeal to, and how much material would it be that would appeal to the prurient interest